morning, everyone, and welcome back to our weekly webinar series. We are discussing very important circulars issued by IBBI today. Over to Anil, sir.
Thank you, Ankit. Welcome to 123rd episode of AAA Weekly Webinar Series. Without wasting any time, we are coming to our subject, the guidelines issued by IBBI for Committee of Creditors. Now, these guidelines are issued as guidelines, not as regulations and not as circular. We would also be discussing another circular for valuation process, which would be attended by Ankit. And also we would be discussing the one very small change in the regulation for inspection and investigations and for issue of show cause notices on the insolvency professionals. So these are the topics that we would be discussing today. So immediately coming to the guidelines issued by IBBI for Committee of Creditors, which was issued on 6th August 2024. Now let us understand the background of this guidelines. In fact, there was a case before Delhi High Court titled as Kumar Sachdev versus IDBI Bank. Now, in that case, Delhi High Court has observed. I would exactly speak what exactly was observed by Delhi High Court. Now, Delhi High Court observed this judgment was dated 12th of February 2024. Now, in this judgment, the Delhi High Court very categorically observed following things. One, the code of conduct shall be effectively based on principles of integrity, objectivity, professional competence, due care, and confidentiality. Furthermore, the code of conduct must also reflect the fundamental features of the Westbury principles of fairness and proportionality in order to give true meaning to the legislative intent of the IPC. Moreover, it should also reflect the principles of natural justice to be followed by the COC while taking any measures with respect to any stakeholders during the subsistence of the entire CIRP. Then the High Court discussed about the powers of the IBBI to make such regulations or guidelines. IBBI is entrusted with a wide set of powers and functions to regulate the exercise of insolvency resolution. It is relevant to take a cue from the Latin maxim, quando lex aliquid camadit, consideri videtur, id sine quo, which translates as, when the law gives anything to anyone. When the law gives anything to anyone, it gives also those things without which thing itself could not exist. If I give a car to someone, I have to give key to the person so that he actually is able to use. Otherwise, the car would not exist. Even also, all those things without which the things itself could not exist is very, very important, because the Committee of Creditor is very, very important. The commercial wisdom of the Committee of Creditor has been upheld many times by the Honorable Supreme Court. Now, the High Court further observed, even otherwise also, the aforesaid provision contains a residuary clause to enable the IBBI to perform such other functions as may be prescribed. The powers of the IBBI is being discussed, and within the powers of the IBBI, there is a residuary clause which says perform such other functions as may be prescribed. IBBI, under the provisions of IBC, is marked with the responsibility to further the speedy resolution and to provide an effective grievance redressal mechanism. The court further observed that the COC takes the driver's seat in this entire voyage of CIRP of corporate debtor. And the commercial wisdom of the Committee of Creditors functions in the same way as the Global Positioning System, GPS, works for the driver in any journey, leading the way to the intended destination. No, it means that the COC is a GPS for the insolvency professionals or other stakeholders, even for valuers. The GPS has to be effective. The COC actually guides us the way through the CIRP. The commercial wisdom of the COC is placed on the highest pedestal in a sense that even adjudicating authority is not empowered to lift the veil on the merits of the decision. I'm reading only the observations, very, very strong observations of Delhi High Court in the case of Umar Sachdev. Considering the significant role which the COC plays in the entire CIRP and the sanctity of the commercial wisdom of the COC, which is protected by the legislative mandate from unnecessary interference, there is a compelling need for the code of conduct / guidelines for the effective working of the committee of creditors in order to fulfill the bona fide objectives of the code. The need for a code of conduct assumes greater importance in the light of the fact that once a decision is taken by the COC, the aggrieved party is deprived of the legal remedies, except to a limited extent. Therefore, what attains significance is that decision-making process should itself be infused with significant safeguards of the reasonableness, fair play, proportionality, and adherence to the principles of natural justice. Accordingly, this court is inclined to partly allow the instant petition with respect to the prayers that the IBBI is directed to frame or finalize a code of conduct / guidelines in accordance with its stand set out in the instant case. Principles mentioned herein above and as per other relevant considerations within a reasonable period of time. Preferably within 3 months from the date of passing of this judgment, for the effective functioning of the COC without diluting the sanctity of the commercial wisdom of the Committee of Creditors and the legislative intent of the IPC. This was the observations, very, very kind of direct the order. It was supposed to be made in 3 months, a code of conduct or guidelines, but also preferably the court directions were preferably in 3 months, but it has been done in a reasonable time. This judgment was dated 12th of February 2024, and these guidelines were announced on 6th of August, slightly less than 6 months. So this is a background of these guidelines. Now, when we see the guidelines which actually were announced on 6th of August 2024, we see that these guidelines are a kind of repetition of the existing regulations, and the guidelines are made in such a manner that it conveys almost everything whatever is already provided in the IBC or in the regulations. But these are all generalized guidelines. What I think it is missing is that since the IBBI did not touch the issue that the professionals are not being paid or not being paid on time, or the financial contributions are not being made by the Committee of Creditors to keep the company as a going concern, or the timely contribution is not coming for effective litigation. So these are the issues which are not touched by IBBI. Now, in case we start touching, one by one. The first heading is objectivity and integrity. It is general in nature. Everyone is supposed to have the objectivity and integrity in life. Why only committee of creditors and the guidelines are not required? These are general human guidelines. Objectivity and integrity. The COC is guided. The guideline says that the COC should follow relevant provisions of the code and regulations in letter and spirit while performing their roles and duty functions. Yes, the COC is doing that. Most of the COCs are complying with this, but yes, it is mentioned now as guidelines. Whereas every human, every stakeholder is supposed to follow the relevant provisions of the code and regulation. Second, which is this clause B, maintain integrity in discharging their roles and functions as envisioned under the code. That is the duty of every human, to maintain integrity. C, maintain objectivity during the decision-making process means that you must first of all fix your objective. What you want to achieve, what is the objective of this discussion, and finally, based on the objectivity, the decision should be made. That is a ordinary course of taking business decisions. Any decisions, even decisions in the family, the objectivity has to be there in the decision-making process. Foster information decision-making. Informed decision-making is a kind of a human trait, is a business acumen. And share with the COC insolvency professionals any relevant information relating to transactions, guarantees, recoveries, claims, etc., relating to the corporate data. No, the COC members are supposed to file their claim, and they are also supposed to file the recovery. They are also supposed to inform the committee members and the insolvency professionals regarding the recovery made or the claims made or any modifications or any transactions or any guarantees that they are supposed to inform. That is something which is mentioned in the guidelines, but they are also doing it, and there is no observation so far that the COC is not doing this. But yes, the guidelines say that they are supposed to strictly follow these relevant provisions of the IBC and the regulations made thereunder, both in letter and spirit, then integrity, then objectivity, and then the informed decision making. Like in case we see the when we see the various relevant sections, section 21 talks about the constitution of committee, which only consists of the financial creditors. As per the history, why only financial creditors? Because it is thought in this country, the financial creditors actually have knowledge, they have the infrastructure, and they have also the capacity in case it is required to keep the company as a going concern. So the financial creditors will take the they will take the status of the GPS. They will guide the driver. They will guide the stakeholders, and the driver will walk on those paths, which is shown by GPS. The GPS must be trustworthy. The COC exactly should function the trustworthy GPS for a driver, like insolvency professional or now even liquidator also. The stakeholders consultation committee is also having the same role, because the powers of the stakeholders consultation committee has been increased over the last 2 or 3 years, and now even the liquidator is supposed to have the consent of the stakeholders consultation committee. So this is where we are saying that the although the sections are also saying the how the meetings would be conducted and how the who actually can call for the meetings, all this has to be done with full responsibility. How the voting would be done, rather the regulations and the sections are saying that the members should actually come prepared for the discussions, prepare for final decision, and prepare for voting. That is what the regulations already says. However, the regulations also say that in case any member who is present in the meeting is not able to take a decision, then he can ask for a e-voting. He can ask for e-voting. That is what, but then the only issue is that these guidelines says that the members who are attending the committee of creditors they must be informed, and they must be empowered, and they must be authorized. Then only they should actually come and join the meeting of the committee of creditors. So now the integrity and informed decision making is absolutely fine. Now the second part of the guidelines is independence and impartiality. The clause E of the guidelines says independence and impartiality, the COC must disclose. The guideline says that the clause E says the COC must disclose to the COC members or to the insolvency professionals the details of any existing or potential conflict of interest arising due to pecuniary or personal or professional relationship with any stakeholder immediately on becoming aware of it. Now, what kind of relationship? That is like kind of any kind of pecuniary or personal or professional relationship. Now, the committee, and that relationship may be with the corporate debtor, that may be with the promoters, that may be with the stakeholders like the insolvency professional, like the resolution applicant, right, with or the valuer, that they must disclose, and the members of the committee cannot appoint. Probably they cannot appoint their related parties as a professional in a company. The independence and impartiality is very, very important, that they should disclose their conflict of interest in any case or any process. That's very, very important. In fact, the approval of the committee of creditors is required under section 28 of the IBC, and most of the important decisions during the CIRP is supposed to be taken by the COC with 66% voting share. So that is very important. In case we look into all these items of 28, these are the very, very important decisions of the CIRP, the process. Now, there are some members who are not supposed to participate into the meetings in case they are related or they have any pecuniary interest, or because of anything they are section 193 even says that the members are not to participate in the meetings where they feel that the decision would be biased or they have a conflict of interest. They must recuse from that meeting in case there are some decisions which are being taken which may harm or which may benefit to one of the related parties of the members. Now, this is then we, in case we move on to the professional competence and participation, then we also have to, then we reach out to clause F. Keep means the COC members keep themselves updated with the provisions of the code, rules and regulations, and the role and responsibilities assigned thereunder. Updated about the provisions of the rules and regulations and code and their roles and responsibilities assigned thereunder. Nominate representative, the COC, like if this COC is State Bank of India, the responsibility is on State Bank of India to nominate a representative with proper authorization and sufficient mandate to effectively participate in the meetings. In my case, so far I have attended personally or virtually, where I am attending the meeting and I'm speaking also, approximately 6,000 meetings. 6,000 meetings, I have seen that only 30% members speak. I am saying very, very with lot of emphasis that only 30% members speak. 70% members do not speak in the meetings. My experience is I have participated in more than 6,000 committee of creditors or stakeholders consultation committee meetings. 70% of the members, they do not participate in the discussions. When we call their name for taking their opinion, most of the answer is that we will go with the majority, or we will take permission from our sanctioning authority, and then we will come back. And as far as this voting, instant voting is concerned, instant voting, not even 10%. Everyone says that we will take appropriate sanction from our reporting authority and then we will vote. Everyone is. So this is something which may have some impact, although it is already there in the regulations. This is not new to Committee of Creditors. They are supposed to nominate a representative with proper authorization and sufficient mandate to effectively participate in the meetings. The guidelines further says the nominated representative may endeavor to obtain approval of the competent authority if required at the earliest. In most of the cases, when we talk about the approval of a resolution plan, the members invariably say that in our bank or in our organization, there is a process of committee decision. And the committee meetings are happening only maybe twice a month or once a month. So we will not be able to vote. We need time till the time our committee meets and the committee approves it. It may be, in some cases, it may be 7 days. In some cases, it may be 30 days. So this is the time that we need the committee members to take decision. The guideline says that at the earliest. No, clause H says that the COC members must participate actively, constructively, and effectively in deliberations and decision-making of the Committee of Creditors. My observations are that only 30% members or participants speak. And the experience of 6,000 Committee of Creditors or Stakeholders Consultation Committee meeting is not less. So this is where the guidelines must be circulated. It must go to the banks through RBI. It must go to each bank's head chairman through the IBBI. It must be exposed that these guidelines are for the members of the Committee of Creditors. This must be exposed. Now, when we talk about the responsibilities are exactly. There is no decision that the insolvency professional, maybe RP or the liquidator, can take himself. Each and every decision has to be approved by the Committee of Creditors. Any effective decision. Now, even the operational decisions, even the operational CIRP cost, even the operational losses, even the operational expenses are also supposed to be approved by the Committee of Creditors. The MIS has to be prepared. Monthly MIS is supposed to be presented in the meeting. It has to be deliberated. There has to be discussions. And the Committee of Creditors must ask questions from the professionals appointed. Now, the Committee of Creditors has been given power that they can access books of accounts, records, and other documents of the corporate debtor, ensuring that the COC members have all information needed to make informed decisions. They have power to access all records. Whatever is required, they can ask from the insolvency professionals. They can ask from the liquidator, and that liquidator will provide that information up to the extent available with him. Also, in case we see the Regulation 4 of CIRP, it also gives a obligation on the Committee of Creditors that the creditor shall provide it to the IRP or the RP, as the case may be, the information in respect of assets and liabilities. Now, banks, financial institutions, NBFCs, ARCs, they normally have the information about the assets and liabilities because, see, they take complete data from the companies while sanctioning and while monitoring. They also take invoices of all those assets in case they have given term loans. Their monthly or quarterly monitoring system of the banks also updates the banks with all kind of information about assets and liabilities. Then the banks are also getting the valuations done on a kind of interval. Maximum is 3 years, and it can actually be done every year. Then the stock statements are supposed to be submitted every month or even earlier in case any change in the drawing power is required. Receivable statement in case any every month or earlier in case any change in the drawing power is required. Inspection reports of the properties, inspections, general inspections done by the bank on the corporates, on the those companies where the companies have taken facilities. Audit reports, stock audit reports, revenue audit reports, title search report, technical officer's report, bank account statement, and such other information which shall assist the IRP or the RP in preparing the information memorandum or getting valuation determined and even conducting the CIRP. So the creditors, banks, information, they are under obligation to provide assets and liabilities, stock audit, stock statements, valuation report, audit report, inspection report, revenue inspection report with regard to that corporate debtor. Also the title search report, technical officer's report, bank account statements, and all this information is supposed to be provided to the insolvency professional, to the IRP or the RP. Now, like, there's nothing to elaborate about it, but then let us move to the next heading. That heading is cooperation, supervision, and timeliness. Now, the clause I under this head says, supervise and facilitate the insolvency professionals in discharging his duties under the code. Certainly, a very, very important duty of the COC, whether the insolvency professional is working or not, whether the RP or the liquidator or the IRP is working or not, what kind of directions that IRP or RP needs for effective working. Then the COC is supposed to facilitate expeditious appointment of various professionals within the timelines prescribed under the code and regulations, that the COC has the obligation to approve the fee of the valuer, to approve the fee of the IPE, to the IP, to the transactional auditor, to the internal auditor in case required, to the statutory auditors in case it is required to be appointed. So all these professionals are supposed to be appointed, even accountant, even the consultants for filing GST returns, in the TDS returns, even for ROC returns. All these consultants are required to be appointed, and the choice of the consultant remains with the insolvency professional, because the insolvency professional has to find comfort of working with a professional, but the fee has to be approved by the committee of creditors. So therefore, the COC's duty is to facilitate expeditious appointment of various professionals. The COC must endeavor to resolve any interstate dispute between the members, particularly in relation to the claims, preferably through dialogue or other non-adversarial means, with a view to avoid litigation to the extent possible. So this is also a very, very important part between the members of the committee of creditors. There are disputes regarding their claims, the amount of the claims, the security interest on the assets. There are disputes, and because of those disputes, they are not cooperating with the process. So they are in fact not cooperating. So they are putting the RP under the pressure, but the guideline says that they can actually settle these disputes through dialogue between them, through their JLM, joint lenders meetings, and by interaction with them, rather than they should go for adversarial means. That's what is the guidelines. So the guidelines are in fact very, very important in case we try to implement and adhere to these guidelines. Then we move on to the confidentiality heading, and the clause L says in the COC must ensure at all times complete adherence to the undertaking regarding confidentiality of information. Now, the guidelines say that they must adhere to the confidentiality obligation. In fact, in case we see this section 29, when we talk about the information memorandum, the information memorandum is supposed to be circulated to the members of the committee of creditors with the confidentiality undertaking. So that is there in the regulations, but the guidelines say that they must adhere to the confidentiality. And then in case we move on to, and the regulation 35 of the CIRP regulations also say that the valuations, details of the valuation of the asset should be circulated to the members with the confidentiality undertaking, so that the valuation is not disclosed to the others, including the resolution applicant. Even the regulation 34 says in the liquidation process regulation that the confidentially undertaking has to be taken from the members of the stakeholders consultation committee. Moving on to the heading 6, which is the cost. Now, the cost of the CIRP, the process, has to be limited, because the overall public and the overall those people who are understanding insolvency a little bit, the largest criticism which has been seen in the first few years is the very high cost of this process in the first few years. Now, when we see, then the minimum fee of the IRP is now regulated, but that minimum fee has become the maximum fee, and since there is a demand and supply gap, there are not many cases, but there are more insolvency professionals. So the market has finally come down to a very, very reasonable fee, very, very reasonable fee. So that is now not a very big criticism in the market as against insolvency processes. But the guideline says that the committee of creditors take necessary measures to ensure that the insolvency resolution process cost is reasonable. They are not saying minimum, they are saying reasonable. So that doesn't mean that we have to appoint a lawyer with 4,000 rupees or with 2,000 rupees per hearing. It has to be reasonable. Reasonable means considering the complexity of the matter, considering the time which is devoted, and considering the experience and the knowledge of the person. It is not said minimum. Even if we are appointing valuer, we should not go for minimum. It should be reasonable. In case we are getting a very large valuation done, and in case we appoint an individual who has just become a valuer, registered valuer, I believe that would not be reasonable. That would be minimum. So the guidelines are reasonable, not minimum. So in case there is a quotation, in case we take quotations from 20 valuers, and one quotation is for 10,000 rupees and another quotation is for 1 lakh rupees. So the committee of creditors has to take a reasonable decision depending upon the complexity of valuation, time which is expected to be taken for such valuation, and should not take experiment with those people who doesn't have experience. So it is not minimum, it is the reasonable. Then the next guidelines is expeditiously decide on all expenses to be incurred by the insolvency professional, including the going concern expenses of the corporate debtor and his fee. Now, including the going concern expenses, that has to be expeditiously decide on all the expenses. No, even for going concern expenses, like we are handling companies where the monthly sale would be approximately 20 crores. So there has to be a process. How the expenses are being incurred, how the approvals are being granted, how the quotations are being treated, how the prices are being fixed. There has to be processes, and the process should be approved as far as the going concern expenses are concerned. There are companies actually who have done something like 10,000 crores of turnover during CIRP, but those 10,000 crores of turnover, it is only process based, not that every purchase, not that every repair expenses, not that every salary or wages expenses are supposed to be approved by the committee of creditor. It is to be approved. It is to be approved as a structure, as a process, as a budget. That is what the guidelines means. It doesn't mean, it is only saying expeditiously decide on all expenses. The word approval is not mentioned here. They can expeditiously decide that this way the expenses would be incurred, and in this manner the company can be kept as a going concern. So it is not, the word approval is not here. Next guidelines is prudently fix the fee payable to the liquidator while deciding to liquidate the corporate debtor. Like it has to be prudently fixed. In some cases, no assets are sold because of the attachment. The committee of creditor must prudently fix the fee of the liquidator, because till how long the liquidator will work. Because I have worked in few cases for 5 years, because since all the assets are attached by enforcement directorate and the fee is settled as per regulation 4, so I haven't got any fee. So I haven't got any fee so far. Now, in all these scenarios, the COC has been given the responsibility of prudently fixing the fee payable to the liquidator. Now, going forward, we actually can say meetings of the committee of creditors. The clause P says regularly. The COC is supposed to regularly monitor the activities of the insolvency professional and seek rationale of decisions, actions taken by him. Next, diligently recommend for inclusions or otherwise of the belated claims collated by the insolvency professionals and categorized as acceptable in the list of creditors, and its treatment to be done in the resolution plan, if any. Then clause R says actively participate in the presentations of valuations methodology by the registered valuer and ensure the conduct of the meeting at regular intervals as specified in the regulations. Although everything mentioned in this heading is already there in the regulations, the COC know that it is their responsibility. But with these guidelines, the COC would actually try to understand that this is the obligation of the COC. So what is the obligation? To monitor the activities of the IP, insolvency professional, may it be RP, IRP, or the liquidator, and also seek the rationales of decisions taken by him. Then this is important, that now the RP has been given the powers to accept the belated claims. But these claims, after the RP will give their own, RP will give his own opinion, then these claims will be presented before the committee of creditors for their acceptance or rejection. Only after that, the communication will be given to the claimant, and then the claimant will have a right of appeal. But the guideline says that the first RP has to verify a claim, and then the COC. It is all about the related claim, and the objective of this particular change in the regulation was to minimize the litigation. So this is also important to to actively participate into the meetings where the methodology of valuation is being discussed. Also, to ensure the conduct in the meetings. So the meetings must not be noisy. The meetings must be having some objective. The meetings must be very, very cordial. So that is all, like ensure the conduct of the meeting at regular intervals. That means that the meeting now, as per the regulations, the meeting can be one meeting in a month is must. The gap between two meetings should not be more than 30 days, but the COC can decide that at least one meeting in one calendar quarter is required, minimum. So the COC will have to ensure that we are conducting as many meetings as required, understanding the complexity, pending issues of a particular case. That's what is the COC's guidelines. So going forward, the heading is sharing information. As I think we've already discussed, the clause T says proactively share the latest financial statements, relevant extract from the audit of the corporate debtor conducted by the creditors, such as stock audit, transaction audit, forensic audit, and all other information available with the insolvency professional to enable efficient conduct of the process. So the information sharing is important. Two-way. One, that the insolvency professional will share the information with the creditors, and the creditors will share the information with the insolvency professional, so that there is no gap. More importantly, what is mentioned here is the latest financial statements and latest stock audit, latest transaction audit, latest forensic audit. These reports are supposed to be shared by the committee of creditors with the insolvency professional. Next is seek details of all litigation filed against or by the corporate debtor from the insolvency professional, and recommend necessary actions to insolvency professional to safeguard the interest of the corporate debtor. Like when we do meeting, there is a separate chapter every time to discuss about the pending litigations and the progress in those litigations. The committee of creditor is guided to seek details of the litigation from the insolvency professionals, may it be in CIRP or may it be in liquidation, and then ask the rationale and ask the like also guide the uh, insolvency professional about the sharing in about the litigation. Now, when we move on, the important part is then the feasibility and viability of the corporate debtor. The guidelines, V guidelines are say that the COC carefully review and assess the information memorandum prepared by the IP and other additional insights. COC must contribute to the preparation of a marketing strategy by the insolvency professionals and may also take measures for marketing of the assets of the corporate debtor, if any. The COC also should ensure that all resolution plans are received by the insolvency professional are placed before the COC. Also, the COC should suitably consider the requirement of a monitoring committee for the implementation of the resolution plans. All and every part of this is mentioned already in the regulations. The COC, the IBBI have in fact separated this from the regulations as guidelines to the committee of creditors, that they actually have to see whether the information memorandum is complete or not. They have to see what is the marketing strategy, how the resolution applicant will be called, what kind of expenditure are being incurred for marketing strategy, whether all the resolution plans are being presented or not, and whether the monitoring committee is required, and if that, who would be the effective monitoring committee is required, depending on the complexity of the resolution plan, period of the resolution plan. That's what it is. So, Ankit, we need to understand now what exactly are the questions on this. Then we have this new circular by IBBI about the valuation process, which you would be taking up. So I think first, because we have 44 minutes, we've already done. So maybe that in case you can speak something about the new circular applicable to registered valuers.
So the new circular applicable for registered valuers is where a VRIN is required to be generated by the valuers. So all the valuers have been given a user ID and a password, the way all IPs always had a user ID and password. And when the RVE or the RV log in into the IBBI portal as a user, they see only one module activated right now for them, which is for generating the VRIN. And that module is pretty simple. It talks about the name of the valuer or the valuer entity. It then talks about, also shows the valuer's registration number. Then it shows that, gives the option to choose the name of a CD. So the way we go on the IBBA website and corporate processes, if we click that, we are able to write the name, and the list of options come out as to which is the CD, which CD do you want to select. So you select the CD, and then that CD is selected, the SIN number is auto-populated. The valuation date is something that then we select using a calendar pop-up. And this way then we click generate VRIN and a VRIN is generated. This is the practical process on how this is happening on the IBBI website. Now the whole thought process behind it is very simple. I think we all, like many of us, are chartered accountants, and we see something called UDIN, which has been implemented since many years. Now before UDIN, there were so many instances of fake certificates where somebody was, writing somebody else's number, making a report, making a CA certificate, and just issuing it without an active membership number. Similarly, today, there can be a control that if somebody is not paying their membership fees, if somebody is having some status that does not allow them to sign a report, due to some action by BBI, then that can be restricted. So they will not be able to generate the VRI into the system. So effectively, they will not be able to sign any report. So this is what is introduced now. There is also one, I think one control that can be implemented later, which can be about the backdating of the reports. So in case there is some timeline as to till what time can the reports be or the VRIN be generated, so that will also then benefit. We already had something called, so certain RVOs already had the system of generating a unique number. So we already, since AAA Valuation is a member of IOV Registered Valuers Foundation, we already used to generate a VRN for every report, and this VRN for every report is generated or required to be generated as long as the report is required for any purpose under Companies Act or under IBC or under CB, wherever it is regulated. So that is what we were already following. Now we are generating this VRIN as per IBBI norms. The circular is very clear that this VRN is required currently to be generated only for IBC related reports. It does not have a framework to generate this for reports which are relating to Companies Act. Right now, the framework is that. We also understand from various discussions that IBBI has done so far with respect to the integrated portal that they are developing, that portal will also integrate valuers within the ecospace of NCLT, IBBI, NCLT, RPs, IPs, and so on. And the valuers will also be able to digitally upload their report and also digitally take the information from the RP. So it will also further improve the accountability on part of the RP to provide the information at a sooner date, and also bring more accountability to the RV to give the report early in case the information was already given to the RV. So these controls and these checks and balances will make this ecospace better. So using technology, I believe we can benefit from being more accountable as professionals and also then bring more speed to the entire process. So this is what is VRIN. In case there are any questions on the VRIN process, then of course I can take that up.
So before we take up these questions, Ankit, there is another amendment, very, very small amendment. I would like to deliberate on that. In fact, on this 13th of August 2024, IBBI have also announced another amendment to IBBI inspection and investigation regulations. Now, inspection and investigation regulations are all about insolvency professionals. And in that regulation, in fact, all these regulations were part of the insolvency professionals regulation, but later on, it was in 2022, a separate inspection and investigation regulations were made, and all those regulations which were there in the insolvency professional regulations has been shifted to the inspections and investigation regulations. Now, in that regulation, the regulation 13 says disposal of show cause notice issued to the service providers, means insolvency professionals. Now, in this case, the amendment is into sub-regulation 2, which says that the disciplinary committee shall endeavor to dispose of the show cause notice within a period of 35 days of the date of issuance of such show cause notice. This was amended on 14th of June 2022, and before that it used to be 180 days. It used to be 180 days, and that was from the day of issue of assessment, from the day. So from 180 days, it was reduced to 35 days on 14th of June 2022. However, I think the IBBI, in fact, is facing a difficulty because 15 days minimum time is granted under Regulation 12 for the noticee to make a written submission. So that 15 days time is given to that noticee. So the balance is only 20 days. Within these 20 days, the IBBI has to prepare and also have to give an option for a hearing. So this was considered to be a very, very low side. So now what they have done on 13th August 2024, this particular 35 days have been increased to 60. And also the 60 days would not be from the day of issuance of the the show cause notices, it would be the 60 days from the due date for receipt of reply to the show cause notice. So that actually means that the 15 days is given for the reply. After the reply, then 60 days is taken by the IBBI. So in total, 75 days. So in case any show cause notice comes to any service provider, any show cause, any insolvency professional, 75 days would be the time in which it would be disposed of. And it used to be 35 days. Now it is 60 plus 15 days. So that is what is the change. There are some changes in information utility. In fact, the information utility is becoming important and more important. So therefore, what we have decided is that the next webinar would be entirely on information utility. We would explain what is the importance of information utility with the amended regulations, with the amended timelines, and with the amended requirements of, first of all, registering a transaction before with IU, and then only we can file an application under section 7 or 9. So that we will discuss in the next webinar. Ankit, we can take up some questions because still we have some minutes, and I can see the participation as huge today. And also the questions would be, I've already seen like many questions have come.
Yes, so I can start with the most important questions. So the first question is that the guidelines do not speak anything about contribution and interim finance to fund the process, CRP process. So we are very clear that the guidelines are silent about it, and we don't see anything there. But at
No,
the same time,
in fact, guidelines are silent on many things which are the difficulties. One, the approval of the fee of the professionals. They are saying facilitate the appointment of professionals, and then like contribution to the CIRP cost, approval of interim finance, and uh, like again uh, expediting the voting process. So these are the issues which are already there in the regulations. Those are not even the only thing is the timely completion is the guidelines. So
second
that
question is that if these guidelines are not followed by COC members, is there any penal process for prescribed under the section under which these are notified or given? What if the COC members do not follow these guidelines?
there is nothing which is provided in the guidelines, and the only thing that we can say that if these guidelines are also kind of recommended by RBI, then it may have some teeth. Otherwise, the IBBI doesn't have any teeth which can be used against the members of the committee of creditors. And also, like not every member of the COC is regulated by RBI. There are private banks, there are NBFCs, there are ARCs, and there are also individuals who are the members. So the overall, as far as the committee of creditors are concerned, and there are institutions. So actually, if you really, like if I have to give an opinion, I definitely see that with the concurrence of RBI, there can be some different separately for PSU banks or the banks, and then some kind of regulations for the other members of the committee of creditors. That can be done. I think that is possible. But then the IBBI has not done this time. Maybe next time.
Then then there is a question which is a separate question, but I think it's an interesting question to talk about. Can one COC member ask for the claim papers, entire claim papers submitted by other financial creditors? Is that a right of the COC members
They
to?
have a right to inspect the claims of each and every claimant. In the meetings, it is the duty of the insolvency professional IRP or the RP that in the meetings he will place all the files, and the members of the COC have the right to inspect.
But the copies can also be given. That's also natural, or should
That is
the
not natural.
RP? So
That
the
is not
RP can
natural.
show the documents to the COC
RP
members
only
through a
can show the
virtual or a
document. It is
physical.
only required for inspection. That is what is
Virtual or
mentioned in the
physical
regulation.
meeting can be done to show the documents.
Yes.
But extracts, taking extracts is not, giving
That is
extracts is
not
not
given
the
in the
case.
regulation, not in the guidelines.
Then the next question is, I think most of these are already taken care of. That the fee is the contribution to the CIRP. All those are the issues that I see, and I don't see that.
So there are some hands also raised in case we have time, Ankit.
Yeah, I'm just taking a few more questions. So the circular with respect to VRI, and I'm making it once again clear, is only for IBC and not for Companies Act as of now. It might be extended later, but right now that is the case. Then we can talk about so I can allow some raised hands to ask their question. Mr. Ravi Sankar, Maharaj ji, and Mr. Reddy, Mr. N.K. Sharma.
Sir, can I say?
Yes, please. Yes.
Okay. See, what I think is that the guidelines have come. Earlier also there was a guideline which said that we need to give mentions in the notice only saying that person who is authorized by the COC should be able, who is attending the COC meeting, should be authorized to take decisions in the meeting. Like that, we can put one more note in the COC notice itself saying that all the COC members are required to follow the guidelines given by the IBBI. Because tomorrow, IBBI may not take any action on the COC because they don't have power, but they will definitely ask us, did you tell them? So I think we should put this note as one more additional note in the COC notice.
So presently the guidelines are final. So this is not guidelines which are open for giving suggestions. Yes, a general recommendations can go from anyone to IBBI that this.
No, sir. I'm not taking recommendation to the IBBI. I'm saying that in my notice to the COC meeting, I suggest that we put one more sentence saying that all the members of COC are required to follow the guidelines given by IBBI. That's what I'm suggesting. Because tomorrow IBBI should be, because since IBBI does not have any power on COC members, they have power on the RP. So they'll ask RP, did the COC follow these guidelines? At least we should say that we brought it to their notice. That's what I thought.
That's a good suggestion, Raviji. I think the RP, while issuing any notice for meeting, can mention that the COC members are requested to adhere to the guidelines issued by IBBI.
Just as sir, I am putting one clause, one note in the this one saying that all members who are coming to COC meeting should be authorized to take decisions in the meeting. Anyway, those who are coming are not authorized to take decision because anyway they have to go back to the sanctioning authorities. But still, we are following it to the extent my permission. I am doing it. That's what I want to say.
Suggestion well taken. I think I also recommend that this kind of paragraph should be there in the notices. Yes, Raviji. Thank you. Thank you, Raviji. Yes.
If anyone else would want to say something.
Mr. Reddy.
Yeah.
Yes, Mr. Reddy.
Yeah. Good morning, Goel brothers.
Good morning, Ji. Good morning.
Yeah, this is my simple question. During this VRIN from IBBA recent amendment from 12th August of this month, whether we have to submit the report also after generating of the VRIN?
No, there is no facility to.
Website?
There is no facility to upload the report. Maybe that will come later in the next the combined portal that is being built. There, this will come up. Right now, there is no facility to upload any document at all.
Okay. Thank you. Because we were worried about that. When once it is uploaded, many of the people may see, and they may utilize this, this report to further their, some other works. Maybe.
It's not to be uploaded.
Yeah. Thank you.
Yes. Mehraj Kumar.
Good afternoon, sir. This is Rajkumar Mehto. Actually, we have touched upon a little bit about that RP fees and minimum fees and maximum fees. So actually, sir, like, with your permission, I would like to put this question before your good. The thing is that, sir, we are grappling with, like, when we are getting an EOI for being appointed as an RP in the matter. Also, sir, liquidators' fees have not been, prescribed as a minimum or maximum. Sir, your suggestion, please.
See, as far as the liquidator fee is concerned, Regulation 4 is prescribing the fee based on the realizations made and the distributions made. While you take up any assignment of liquidation, in case you find that the company doesn't have any asset, because as a liquidator, it is very difficult to say that I have no knowledge when I was appointed, because see, the RP has all the knowledge. So liquidator, whenever the liquidator is getting appointed, he can even touch base with the RP to ask whether the company has any assets and to what extent. In case the proposed liquidator feels that the assets are not enough to cover the liquidation process of 2-3 years because of the buffet transactions, then the liquidator can also propose a monthly fee either along with Regulation 4 or without Regulation 4. So the liquidator appointment is not automatic now. The liquidator's appointment is with the consent. And in case the liquidator is not interested, then the liquidator may not give the consent. But nobody can say that the liquidator kahin phas gaya. No. The liquidator's decision is very, very informed decision. It is not like CIRP, where when somebody is appointed as our IRP, he would not even know whether he is getting appointed or not. But for a liquidator, he will definitely have information. So therefore, the liquidator will be able to take an informed decision. Maybe based on Regulation 4 or maybe based on monthly fee. As far as this CIRP is concerned, minimum fees are prescribed. Even if your fee is not approved by the Committee of Creditors, the minimum fee has to be paid to you from whatever sources it comes to. And in case it doesn't come from anywhere, then I think the applicant has to give, in case the CIRP gets quashed after say 2-3 months, then whatever time that you have spent, the cost, the fee would come from the applicant, not from the corporate debtor. This is my opinion.
And what about, sir, personal guarantor to corporate debtor? RPs are appointed, and because the minimum fees are not prescribed therein.
Even for the personal guarantor, if you are appointed, if you have given a consent to IBBI to get appointed as a RP, then the NCLT can pick up your name from the panel. And then in case you find, because most of the banks are giving the fee, which is a monthly fee for 6 months. And you can also negotiate with the banks that you also need a fee for preparing a report under Section 99. And you can also say that you are required to appoint lawyers, so you can actually deal with the applicant bank. Because in this individual insolvency, it is the applicant bank who will pay the fees. And finally, whatever the repayment plan will come, out of that repayment plan, this fee will be reimbursed to the bank, applicant bank. But the fee is little lesser, as the banks are not giving very high fee for PG cases. But the banks are giving fees. It is not really many cases that the banks are not giving. Because if they are applicant, they have to give fee.
Yes, sir. Thank you very much.
So, Ankit, next.
So, I think if anyone else would...
Yes, I have one question.
Yes, please go ahead.
In case of big banks who are COC, what they say is, even if they some AGM attends the COC meeting, he says that for everything, I will require the approval of our higher authorities. And then they take a lot of time. Say for, okay, for resolution plan is okay, but for whether to liquidate immediately or not, such decisions, they take a lot of time. And the people who are attending the COC don't have that much authority to discuss and take the decision. What can be done in this?
No, the guidelines are very clear that the committee, the members have to come with the one, preparation, number two, with the authority, and with proper mandate. These are the guidelines. and the COC member should adhere to the guidelines. So in case they are not adhering to the guidelines, I think then as far as this RP is concerned, RP should place all those things in the minutes. Nobody can ask any question to RP that why the process was delayed, because now what is happening? Now the RP has no power to extend the voting period beyond 7 days. And in case of any further requirement, the creditors have to send an email, and then the RP has only power to extend by 24 hours. So in case the voting is getting extended, that means every day the RP is getting an email from the creditors, and those emails are part of the records. That means that the RP is not sleeping. Second, that the committee is also considerate. They are also kind of watching the process every day. Then only they are sending the mails. So by this regulation, which has been introduced by IBBI in probably February 24, this has really impacted. Now the decisions are pretty faster as against the past.
Okay, thank you.
Also here, just to add that we have also started including in the minutes of the next meeting the date on which the voting was opened and the date on which the voting was concluded. So this also creates a lot of accountability on part of the COC members to make the voting faster. Secondly, prior discussion or telephonic discussion with the COC members on the agenda items also helps expedite the voting process in our experience.
Yes.
So this
Yes, Gupta.
my question is on the latest circular change amendment regarding the disposal of show cause notice.
Yes.
So as it says that it shall endure. Now, shall endure means, is it a mandatory or directory only? Because many a times it has been seen that the show cause notices, even after the reply has been submitted, are pending for months and months.
It is directory only, because the endeavors means it is directory. But like as far as I understand, the natural justice, the complexity of case, the proportionality, all these factors when we consider, and finally, in case there is a unreasonable delay, then probably the court will decide sympathetically in favor of the insolvency professional or the service provider. That's the only thing that we can say. But yes, when the word comes endeavor, it actually means that they will try. However, in case they are not able to try, then they are supposed to provide reasons in case asked by the court why they took more time. So that is what I feel the meaning of this endeavor would be.
Mr. Goel, I have two questions relating to para Q of the guidelines. One,
Yes.
I have placed on the chat box. That is, resolution plan is approved by the COC and pending adjudication by Honorable AA. Now, some of the claims or belated claims. Now, in view of the Puneet Kaur case, Honorable NCLT has approved some of the claims, those who have approached the court. Now, what will be the impact on the resolution plan?
Now, in most of the cases that I've seen, like for example, if one amount, maybe 20 lakhs, is offered to operational creditors.
Yes.
And in the process, there are the operational creditors are increased by 10% because of these additional claims, which finally the RP is directed to admit. Then the proportionate amount to each operational creditor will reduce. This is the impact number one.
But this is just a real, sorry for interruption, this is a real estate matter. Now, once I admit the claim, it means the particular space will be allotted to him.
Now, see, in the resolution plans, yes, normally what we are doing for real estate cases, we are actually asking the resolution applicant to add a paragraph for those allottees who are not able to file their claims during the process. Then we are saying that they are allowed to file their claims before the monitoring committee. And the monitoring committee will deal those claims in the following manner. that manner is also given in the resolution plan. So this one paragraph in the resolution plan actually have resulted in minimizing the litigation to a huge extent. Because
Okay.
even after that, any claimant goes to NCLT, the respondent means the maybe monitoring committee will simply show that paragraph, and immediately that particular application will be disposed of by saying that the resolution plan already deals with you people like you who are filing the claims belatedly, and that too even after the resolution plan is approved. So that actually has minimized the litigation to a great extent.
But
by
sir,
adding one paragraph or by
as,
just
as per the Puneet Kaur orders, equal treatment shall have to be given to those cases where the tribunal has condoned the delay in filing of the claims.
but then that is only in case there is not when the resolution plan is approved by the committee of creditors,
Yes,
and it would be binding on all the stakeholders.
that's right.
And equal, like everyone will be given equal treatment. There are controversial judgments. There are judgments in favor of equal. There are judgments not in favor of equal treatments. Because see, there are judgments which even says that to some of the operational creditors you pay 100% because they are important for continuing the company as a going concern, and for rest of the operational creditor you can pay even zero. So there are judgments that you can actually have objectivity and selectivity in settling the claims in a resolution plan. The only thing which is required is that the resolution plan must be approved by at least 66% of the votes, and then it is binding on all the stakeholders.
So my second question is now number of claims are still lying with me. Those who are belated claims, those who are not approached the court. What do I do with those claims?
No, you have to say only one thing, that the resolution plan has been approved. All my powers are not there. I have no power to accept a claim because my powers were only up to the up to one.
That we have already conveyed to them. But any effect on the para Q of this code of conduct?
No, like para Q is like that is only while the resolution plan is not approved. After the resolution plan is approved by the committee of creditors, there is no power with the COC, there is no power with the RP, the only power is with the NCLT.
But the word written is belated claims.
No, the belated claims are, see, there is a timeline given in the CIRP for the filing of the claim. That is the maybe 7 days from the end of the, I think that is the timeline is given. No, beyond that time, every claim is a belated claim.
That's right.
We are not talking about those belated claims which are filed after the resolution plan is approved by NCLT.
Approved by the COC. Right. Thank you very much, Mr.
Yes. So I think we should conclude.
Yes, I think so too. I think we are already 15 minutes up, so we should wind up now. Thank you so much, everyone, and thank you for such active participation today. Really encouraging for us.
Yes.
Thank you.
Thank you. It is our way of learning. Thank you very much.